to his wife.
The court therefore orders the paragraphs referred to as offending the law are hereby expunged from the witness statement of PW1.
Meanwhile, lawyers for the EC have been subjecting Mr. Nketia to questions, suggesting to him that agents of the party's presidential candidate signed majority of the collated results.
You train them that after collating on some 9, the results will be entered on some 10. Is that correct?
That's correct, my lord. But all with the involvement of our agents.
We'll bring you details. Top Story is brought to you by Blackcom Mineral Water, Vodafone, the future's exciting, ready, and Gasm Cement, the nation builder. My name is Ernest Menu. Tonight, the Supreme Court struck out portions of the witness statement filed by the General Secretary of the National Democratic Congress, Johnson Asiedu Nketia. Now, this followed objections raised by President Akufo-Addo's lawyers, who said the allegations had not been stated in John Mahama's petition, aside from they being scandalous. Now, listen to lead counsel for President Akufo-Addo, Akoto Ampao, explaining why some portions of the witness statement should not be accepted.
Risk that the admission of the evidence will create substantial danger of unfair prejudice or substantial danger of confusing the issues. Now, my lords, the relevance of this piece of these provisions of the Evidence Act is that they confirm the position that any evidence that will be led must be based on the pleadings and be related to an issue in dispute. And that pleadings, evidence that spring from nowhere surprises the other party. And where they do cause, where they provide a danger of substantial or unfair prejudice, may be disallowed by the court. And that is why we believe it is relevant. My Lord, it is for these reasons my Lord, with all due respect, my attention has been drawn to paragraph 37 also. Yes, the last of any paragraph, where the witness states, I quote, "This conduct of certain officials of first respondent in padding the votes of certain respondents is in fact indicative of a well-hatched and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of the first respondent to have second respondent unconstitutionally and unlawfully installed as president." My lords, this paragraph is extremely scandalous, and what makes it worse is that apart from the so-called 4,000 plus padding that they allege, and they have not provided any further evidence or made any further pleading, indicating that there's a well-hatched and sustained pattern of manufacturing numbers unrelated to the votes. There's nothing in either their petition or there's nothing in their petition to that effect. My lords, I think it is.
So you had the lead counsel for President Akufo-Addo. Now, Chachi Chikata, who is lawyer for the petitioner, John Mahama, justified the inclusion of the paragraph in the witness statement, saying the foundation of the petitioner's case rests on those paragraphs.
Saying there was a predetermined agenda, and we're saying that that predetermined agenda is evident from the ever-changing circumstances and from the refusal to act in accordance with the responsibilities to be fair and candid. We say in paragraph 22 that she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. We say in paragraph 23 that prior to her making the said purported declaration, Mrs. Gina Adokwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of these concerns. My lord, if evidence cannot be given in relation to all these matters and how they lead to the inevitable conclusion of a predetermined agenda, then respectfully, I don't know what else we're supposed to do in terms of providing evidence. We go on in paragraph 30. In paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. My lord, I mean, one should, with respect, take cognizance of the various elements of our paragraphs in the pleadings. The fact that there's no explanation, there's a total lack of transparency, these are all things that have been pleaded. And if evidence is being led.
And so that is the counsel for the petitioner, the lead counsel for the petitioner, John Mahama. Chachi Chikata, the court correspondent, Joseph Akable, joins me in the studio. A lot happened today. But let's start first with the position of the counsel for the Electoral Commission on his position on these objections raised by Mr. Akoto Ampao.
In fact, Mr. Menuvo didn't make any oral argument beyond saying that he agrees with the views that were expressed by Mr. Akoto Ampao. And so the court went for a recess, and when the court came back, the ruling they gave was to the effect that there are portions of the witness statement that are not based on the pleadings, i.e. the things that have been said in the petition, and also making the point that they were scandalous. And so there were some aspects of it that he said that Mr. Seydou Nketia cannot testify to. And so he set aside those portions of it. So in all, it came to about 7 portions of the witness statement that were set aside, whilst the remaining were maintained.
The remaining were maintained. Now, after this, after the court process, we first of all, the counsel for the Electoral Commission actually started the process of cross-examination. What were the highlights of that process?
It centered mainly on finding out from Mr. Seydou Nketia the kind of training that they took their agents through. And the point the EC council sought to put across was the fact that, one, they were thought that they had to be at the polling stations, they had to go through the process. If they had any concerns, they could raise it, they could sign to the results that were declared. If they didn't want to sign, they could object. On the other hand, if they failed to sign as well, it didn't stop the process from going on. Then came the point about the Techiman South constituency results. And the point the EC lawyer was putting across to Mr. Seydou Nketia was the fact that as at the time the petition was filed, and as at the time Mr. Seydou Nketia filed his witness statement, the Techiman South results were actually known. And so he should not have been engaging in the analysis that he engaged in saying that at the time the EC chair declared the results, if you add all the Techiman South results to that of Mr. Mahama, it will mean that no candidate got more than 50% of the votes cast. But Mr. Seydou Nketia kept insisting that he didn't agree with that because his analysis was purely based on the declaration that was done by the AC chairperson on December 9th.
And he also tried to get him to admit that a number of the collated results from the regions were actually signed by agents of John Mahama.
Specifically, he says 13 of the 16 regions results, and he made the point that the remaining were actually places that were won by Mr. Mahama. And at that point was where, for those who were watching and listening, that was when Mr. Sedin Ketia kept saying that no one wins any region. In his response, when he was asked who won Greater Accra region, he said no one wins any region and that there's just one constituency, i.e. the whole country is declared for presidential results.
So after that process, the second respondent also had a stand. Mr. Akoto Ampao started the process of cross-examination. Tell us what happened.
It was quite brief because a request was put in at a point when he was suggesting to Mr. Sedin Ketia that leading members of his party, including himself and the petitioner, had publicly claimed that they had won the election prior to filing the petition. And so he had wanted to confront him with a video that captures key individuals of the NDC claiming victory after the declaration of the results. And so the court, after that application was made formally, the court took an adjournment to come back on Monday to have that particular video played to the court.
And as we've seen throughout the proceedings, after the court process, you have some of the counsel speak to the media. Now, Frank Davis responded to a number of issues which happened during the cross-examination. First, on the issue of whether or not, which was actually where the cross-examination for Mr. Akoto Ampao, truncated, the point about whether or not their claim of John Mahama winning the election goes to the credibility of the witness in the box.
Mr. Davis insists that the witness was being evasive when was cross-examined, and so in terms of beyond that particular point about him being evasive, he says the video that will be tendering and playing to the court on Monday will show that he's not a credible witness because he publicly made pronouncements that are not backed by the petition that they've been able to file subsequently.
But Mr. Ayene, when he had his time to also speak to the media, took time to respond to those claims.
He says their case is hinged on a declaration by the EC and errors were made, and as far as they are concerned, per that declaration, no one got more than 50% of the votes cast, and this is what they've brought it to court. And those who say they don't have a good case are now having a second thought because their case is solid.
Court correspondent Joseph Akable there. Let's go on to the phone lines now and speak to one of the legal team members of the petitioner, of the second respondent, actually. Lawyer Yao Opon, private legal practitioner, joins us on the line. Thank you very much, Mr. Opon, for your time here on Top Story. Is it that you were taken by surprise? You did not anticipate that you would start with a cross-examination of the first witness for today, which is why you could not play the video because provision was not made?
Oh, thank you very much and good evening. Well, no, we're not taken by surprise. We were not the ones to provide the facilities for playing the tape or the video. It's the court, and the court also asserted it. Even when we want to supplement or assist the court in facilitating the process, remember the Chief Justice said it in jest that they were thankful for our unsolicited assistance or words to that effect. So we were ready, and the courts have these systems. But I think that perhaps the anticipation had not been that it was going to be played today. So I think by and large that has been resolved. On Monday, we are ready to play it. It has been attached to the witness statement which was filed, I think, a couple of weeks ago, about a week ago, and we are ready to show it to the whole world.
Now, Dominic Ayene, who is part of the legal team of the petitioner, actually raised a number of issues. I want us to listen to him briefly, and I'll take your response on that.
All right, quickly.
Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013,
His Excellency Nana Adodankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Adodankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change and compel him to testify? I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls. Also, it played out in court today that if we had done proper case management, as we were pushing, we would not be where we were this afternoon.
Mr. Opon, you had Dominic Ayene. Essentially, I want to start with the last point he made, that if we had done proper case management, the issue of your inability to play the video would have been dealt with. Do you agree with him on that?
But if you may permit me, let me rather start from the beginning, the first part.
The first, we'll come there. We'll come there. I just want us to deal with this.
I mean,
it is the substantive issue which we'll address, but if we can deal with this quickly.
Right. On that point, the CI-99 does not per se provide for case management. It provides for pre-trial. And the pre-trial system, as we know it, at least at the commercial court, has its own mechanisms that have been infused into the laws. And then the CI-99 uses the same term, but it is for the court to now determine whether what the law means by pre-trial, it is in the nature of case management. Because with the pre-trial, as we have seen played out here, it means if we were in the High Court, the application for direction stage, the filing of witness statements, and then directions given us to the trial. At the time that my very good friend, Dr. Ini, previously spoke about case management, at that time we had not even filed witness statement. Normally, case management, as we know it at the High Court, starts at the time that witness statement had been filed. Of course, it appears this pre-trial system is a fusion of both all matters that are resolved, including the setting down of the issues, and then also the filing of witness statement. We have gone through that, and it has ended. I think if there was the need for further direction, as they also attach a video to the witness statement of the petitioner, it was both the duty of the petitioner and the respondent, that's those of us who have something to show, at any point in time when you are desirous of showing it, to just bring it up. I don't think there was any deficiency in the process that is being referred to as case management, but which I say is pre-trial, at least using the term that is used in the law. I don't think there was any deficiency in it. And when you want to confront a party with a video or an audio, it can always come up at the time that you want to show it, and facilities will be ready.
Very well.
I mean, the matter has been resolved. Monday, we will just come over and do that. I don't think that anybody...
Now, on the substantive issue of Mr. Asiedu Nketia repeatedly making the point that he is not the petitioner, and that was reiterated by his counsel, Chachu Chikata, that he is not the petitioner and therefore could not answer some of the questions that your lead counsel put to him. Your side, and when you listen to Frank Davis, seem not to be happy with that. Do I get the indication that going forward you would apply to the court for the petitioner to be in the box, or at least his representative?
Oh, no, I mean, there's no need at all. I mean, a party, the law is clear. There's a case in Ria Shalbuche. It was Mrs. Georgina Wood, CJ then, who stated categorically a party need not give evidence himself in a case. I mean, that is clear enough. But the point that Mr. Davis sought to establish was that, and it was he also earlier indicated, and the court was indicated, that because Mr. Asiedu Nketia is not a lawful attorney or otherwise a representative of the petitioner, one, it would be unfair to put certain specific matters to him that are expected to be in the exclusive knowledge of the petitioner, and it came out, and that is why consistently Mr. Edwin Ketia was saying that I cannot speak for the petitioner.
But that affects your case then, because that affects your case then, doesn't it? Because then a number of the questions.
The petitioner is doing his case. His lawyers are well informed, very experienced lawyers. They have a way of prosecuting their own case. We have a way of prosecuting others. But this is how they have decided to go, to prosecute their case. They know their case. They know the burden that is imposed on them to discharge. So it is not for any of us to question how, in my view, how they want to do their case. At the end of the day, if they will decide to apply the knowledge, the principles that are elementary and basic, and still be able to discharge their burden as we know it in law, I think that is the ultimate. Burden will determine what you do, who you call, and so on and so forth. But the point really about whether Nana Kojo testified in 2013, I think that Dr. Aini, unfortunately, in my view, got it wrong.
Very well. Thank you very much. Mr. Pon, I want to thank you for your time here on Top Story. We're running out of time on this. We're joined by private legal practitioner Martin Pebu for some education on this. There were a number of issues for us lay people who are learning from the event of 2013. We saw some issues come up in court today, and Mr. Pebu will help us understand. Mr. Pebu, I'm grateful you could join us. Now, first of all, we did not see Mr. Chikata lead Asiedin Ketia in an extensive, for want of a better expression, examination in chief to make the case. It was rather to introduce him and say, and then we have the cross-examination from the Council of the First Respondents. Has the rules changed in that regard?
Yes, definitely. The rules have changed. So that's why we have the witness statements. Hitherto, the witness would enter the box and narrate the whole of his case. Well, that's what is brought to court, which we call technically examination in chief. Okay, but with the introduction of the witness statement, it's supposed to write all of those on paper and attach his evidence. So in this case, if there are pin sheets, collation sheets, all those, attach them on paper, so that this is meant to expedite the trial, so that when the witness mounts the box, he will just ask a few questions. What is your name? Where do you live? What work do you do? And then why is he here? Basically, these are most of the questions. Then he would show, have you given a witness statement to the court? Then he would show, or have you filed a witness statement? Then he would say, yes, take a look. So when he identifies his signature on the witness statement, then they would pray the court to accept it. So you see that in 2-3 minutes, they are done. So, and note that before that witness mounts the box, the opponents have already been given copies of that statement. So in this case, the pursuant to the orders of the court, the witness statements were served before. So the president's lawyer and the EC's lawyers all have copies. So they've already prepared their lines of cross-examination. Then they would go ahead.
And I also noticed today that we had Mr. Akoto Ampao make an oral application for the video to be played. Now, if I recall, in 2013, when we had the election petition, Mr. Addison was asked to apply to the court for that provision to be made. What has changed this time round?
The Supreme Court is master of its rules. Don't forget, this time we have 42 days, most of which are already gone. So in this context, it will be unduly burdensome to say they should go bring a formal application in writing. So I should think that's why the Supreme Court considered it, that, okay, this can be played. And also, this is in cross-examination. So in cross-examination, there is that latitude to introduce evidence that will affect the credibility of a witness. So you are not bound for evidence that will impeach a witness or destroy its credibility. You are not bound to bring advance notice of those. No. There is still the right to bring up the evidence at any time. So it will be unduly burdensome that at the time the lawyer seeks to introduce the evidence that will be used to impeach the witness, then he's told to go and bring a formal application.
Now, for the portions of the witness statement that was struck out, is there the opportunity, and I had Mr. Ayene make the point, is there the opportunity for the petitioners to raise this issue subsequently?
Well, so let's say theoretically, there are ways, depending on how they phrase the questions, there are ways that they could smuggle this in through the back door. Okay, so something like, let's take a typical example. The one that says, that one would...
Mr. Tun, we are losing you along the line. If you could just position yourself.
Hello?
Yes, it's better now.
Yes, so I said there are ways that some of these questions, some of the questions can be phrased in such a way that that evidence will be elicited through the back door. So let's take a typical example, paragraph 25. The decision on that, the part that says the ever-changing figures put out in the unsigned press releases, blah, blah, blah.
Yeah.
We know that it's a key part of the analysis.
Mr. Tun, we are losing you again. We are losing you again. If you could just turn around for us, I'm sure we'll have a better connection to you.
Hello?
Yes, this is good.
So I said we're just using one example. Mr. Mohammed's case is that Mrs. Mensah brought out so many results, right?
Yes.
And so in paragraph 25, they said the ever-changing figures. But I'm saying that, so that, for instance, when Mrs. Jim Mensah mounts the box, they will ask the number of times she changed the results. So cancelling it from Mr. Sedun Ketia's witness statement doesn't really change anything. So there are opportunities for some of those evidence to be elicited through cross-examination of the EC.
And finally, as we wrap up on this, for purposes of clarity, the case can run without the petitioner in court. And we saw in 2013, Dr. Bawumia represent the two others in the box. Is it the case, and Mr. Opong just alluded to that, and I don't know if you agree with him, that throughout this case, it can be done without the petitioner in the box?
Yes, most definitely. That's the law, and it's been the state of the law for decades. Okay, there are, even apart from the 2003 decision is referring to, there are decisions dating from the 50s and all that. It's a settled principle that in a civil case, the plaintiff, or in this case petitioner, is not bound to testify. It's a strategic decision. He has to assess the case. If he thinks that the case is such that he has to depend on others, so be it. He's not compelled to testify. Yes.
Mr. Tulu, I want to thank you for your time. And that's private legal practitioner Martin Table bringing us some education on the proceedings in court today. The case has been adjourned, and once the court resumes sitting, you know that definitely we're going to bring you updates here on Joy 99.7 FM. That's it for Top Story, brought to you by Belacqua Mineral Water, Gasam Cement, The Nation Builder, and Vodafone. The future's exciting, ready. Ghana Connect is up next after this break. Stay with us.
Our 130-year journey at Allianz has seen our operations growing to cover over 92 million Allianz customers in over 70 countries worldwide. Allianz